would be good. It would be good to have all the water rights on the Gila River adjudicated, because Arizona doesn't have a riparian water rights system. We have what's called prior appropriation, which is basically, you know, whoever gets their first wins. So water rights are based on a priority of when you can establish using the water, and I'm highly simplifying this. But Salt River Project thought it would be a good idea to have all these rights adjudicated. And so everyone would kind of know where they stood when it came to water rights on the river. And the lawyer says, well, you know, this is going to be expensive. It's going to take a long time. I think it might take like 10 years to get this resolved. Well, fast forward 4 decades. and they're still there. And so when I worked at the city of Tempe, I would have to go to some of the water adjudication, monitor some of the water adjudication stuff, and it was quite fascinating to see. Everybody's still there. Careers, I mean, people start their law careers and retire, and the adjudication lives on. And so 10 years with that would probably, you know, would be enough to drive anybody, you know, batty.
How'd you get rid of it, Susan?
Well, I got rid of the first one by leaving the state court and coming to the federal court.
Ding, 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 ding.
And I got rid of the second one by telling my chief judge that I didn't think that I thought it should go to a judge who had more longevity than me.
You know, which is based on the history is like a fair point.
Well, but the Gila decree,
yeah,
while I had it, turned 75 years old. I mean, it never ends because it's the administration of the decree. And so I thought a new judge who had a lot of years left should get it while I was still around in case there were any questions. So it took him like 1.5 years before he reassigned it, but I got rid of it about 3 years ago, I think. But no, it's fascinating once you get into all of the arcane water rules and water rights. And speaking of arcane, Shelley, was that like a great segue for you?
That was. So, and we'll go ahead and get started because I have a lot of material to cover and not a lot of time to do this. The last time I gave this presentation, it took 1.5 hours, but we'll be skipping some stuff, I think. And I'll try to make this as easy as I can on everybody. So I'm going to try to see if I can share my screen. Okay, so I'm going to try to share this. Whoops. Can you guys see that? Excellent. Okay. So defining waters of the United States, right? That sounds exciting. I think everybody here on the call pretty much knows me a bit. So this year is my 25th year as a lawyer. And my first job out of law school was clerking for a judge on the Arizona Supreme Court named Ruth McGregor, who was who's actually a former member of our club. And I've spent about 1/3 of my law practice here at the AG's office practicing environmental law, representing both the Arizona Department of Environmental Quality, ADEQ, and formerly the Arizona Game and Fish Commission is in department. And before I was a lawyer, I was a soldier, and I was a Russian linguist in the Army. So that's everything really about me. So why are we doing this presentation? So last spring, Sarah Porter from the Kyle Center came to our club and talked to us about water policy, really related to water quantity issues and drought and climate change and that sort of thing. So this is sort of the flip side of that coin and talks a little bit about water quality, because of course we can have all the water we could possibly need, and if it's horribly polluted, we haven't really done much good for ourselves. So what are the goals? The goals are to kind of have an interactive, engaging dialogue. If you have comments or questions, I don't see everybody on here. So if you want to unmute yourself and just shout, hey, Shelley, and ask your question, I'll be happy to answer it as we go along. And the main thing I'm hoping everybody gets out of this is that, you know, the definition of waters of the United States, or WOTUS, in the Clean Water Act, you know, they're just not just words in a statute. They actually have practical impact on Arizona and on the state of our water quality. So kind of make the law and talk about how it practically, you know, how it affects us in the practical real world. Okay, so a disclaimer. The opinions that I'm going to express here, and you know, we all have opinions, they're mine. So they're not necessarily the opinions of my client or the Attorney General's office or the state of Arizona. So just so everybody knows that. Okay. Origins of the Clean Water Act. How the heck did we get a Clean Water Act? Well, on June 22nd, 1969, the Cuyahoga River in Ohio caught fire. It was so polluted, the water caught fire. Okay, and here's a photo of that fire. And this event really was a seminal event that really served as a catalyst for water pollution control efforts at a national level. Because before the EPA, the Environmental Protection Agency, was created in 1970, and before we got our Clean Water Act in 1972, water, you know, pollution control was really handled by piecemeal state efforts, right? But water, as we know, does not respect borders. If you have a river that runs from Ohio into Pennsylvania on its way to the Mississippi River, let's say, and Pennsylvania has really stringent water quality laws, and they do a lot to prohibit water pollution, but Ohio really doesn't do anything at all. Well, your laws in Pennsylvania don't do you any good, because all the polluted water from Ohio is going to flow into your state. So that's why Congress decided some efforts at the national level were required to kind of stop this sort of thing from happening again. So what do we have? The Clean Water Act does a lot of things, but for purposes of our conversation, it establishes federal jurisdiction over quote unquote navigable waters, which the Clean Water Act defines as waters of the United States, or WOTUS. Not waters in the United States, waters of the United States. Well, Congress didn't define waters of the United States. And so this has created decades of ambiguity and fighting ever since. And you really have what we lawyers like to call the Lawyers Full-Time Employment Act, because as long as there's this ambiguity, there's fighting, and we all have jobs. Okay. So the Clean Water Act makes, among other things, makes it unlawful to discharge or dump pollutants from any point source. And point source is a rabbit hole all of its own. Okay, you can spend your whole day reading cases about point sources, but you can't dump pollutants from a point source into a WOTUS without a permit. Okay, this is part 402 of the Clean Water Act, so they're kind of called sometimes 402 permits. A point source, think about it as any sort of defined conveyance. So a ditch, a pipe, a tunnel, a boat, right? Any sort of distinct, discrete point, that's going to be a point source. Now, the EPA has delegated authority to the state of Arizona to issue these Clean Water Act permits for the discharge of pollutants into a WOTUS. At the national level, for jurisdictions where EPA issues these permits, they're called National Pollution Discharge Elimination System Permits, or NPDES permits. So in Arizona, we call them SIPhx permits, because we just took national and changed it to Arizona, and everybody loves their acronyms, and their jargon. So we call them SIPhx permits. And these permits limit the amount of pollutants that can be discharged into a WOTUS to try to protect the water, you know, the quality of the water. Now, these permits can be either individual or general, depending upon the kind of activity that someone's engaging in. These permits can be quite lengthy and detailed. I've read permits that are over 80 pages.
Jeez.
And the permits typically include a lot of monitoring requirements, best management practices, contingency plans. In the event that you have an exceedance of pollutants that you're discharging, what is that mining company, whoever has the permit, what are they obliged to do to fix the problem? So this is the kind of things that these permits address. Now, if you're familiar with, say, the Civil Rights Act, right? Title VII of the Civil Rights Act gives a baseline of protection for people of various protected classes, but states can give people more rights, right? The federal law is the floor and not the ceiling. The Clean Water Act works the same way. So from a federal perspective, the Clean Water Act is sort of the baseline of protection, and states are generally free to protect waters to a greater degree than the Clean Water Act would require. But in Arizona, our statutes are often written by industry. And so when Title 49, which is the set of laws that govern ADEQ, was created, the legislature put in Title 49 a provision that forbids ADEQ from being any more stringent or protective of waters than the Clean Water Act allows. Okay? So Arizona is a bit hamstrung in some ways in its ability to protect waters. So womp womp. Welcome to Arizona politics. Okay. There's a flip side of the Clean Water Act permitting coin. In its Part 404 of the Clean Water Act. And the Clean Water Act also prohibits the discharge or dumping of dredged or fill material into a WOTUS without a permit. So if you think about, it doesn't come up, Rule 404 permit issues don't come up very often in Arizona, because these permits often come into play when there's construction in or near wetlands. So let's say you have a marshy lot that you want to build a house on. This is where this provision comes into play most often. And the U.S. Army Corps of Engineers, not EPA, a whole nother agency, a whole nother part of the government, issues 404 permits. And Arizona is not a delegated state for this particular program. So in Arizona, when there's a 404 permit, a dredge and fill permit, it's not administered by the Arizona Department of Environmental Quality. That's handled by the Army Corps of Engineers. So why do I mention all of this? Okay, we're going to have like a constitutional law minute here. So there was a 20th century American historian named Richard Hofstadter. And he surmised that when the founding fathers created our three branches of government, the legislative, right, Congress, the judicial, the federal courts, and the executive, the president, and all the executive administrative agencies under that, their goal, the founding fathers' goal, was to set up a, quote, system of mutual frustration, where not one branch of government could make all the decisions, not one branch of government had all of the power. So notice that Congress seems to have followed this same logic in the Clean Water Act by giving the EPA some authority under the Clean Water Act and giving the Corps some authority under the Clean Water Act. And the Army Corps of Engineers, one of the things that they get to do under the Clean Water Act is make determinations about whether a water is a WOTUS and whether it's protected under the Clean Water Act. And these are called jurisdictional determinations. And anybody can call up the Corps and say, hey, is this a WOTUS? And, the Corps will investigate and issue an opinion. But, EP and the Corps don't always agree on whether something is a WOTUS. And there have been disagreements in Arizona historically, which, causes problems. If you're a company and you're trying to figure out whether you need to get a permit, if you're ADEQ and you're trying to figure out whether you have to require someone to get a permit, and EPA and the Corps are fighting over whether something is a WOTUS, you're just kind of in limbo until they resolve their dispute and figure it out. So it can create some regulatory nightmares. Now, as we discussed, the Clean Water Act doesn't define WOTUS, so EPA and the Corps over the years have put their heads together and defined WOTUS in their administrative regulations. And in 1986, you get the first definition of WOTUS. Now, from 1972 to 1986, you had no definition. So I don't know what the Corps and EPA were doing really between 1982, you know, and the time they passed that rule. Maybe they were just winging it. I mean, I don't know. But even the Supreme Court didn't even weigh in on this WOTUS issue until 1985, and we'll talk about that in a minute. So what did the Reagan administration do in terms of what is a WOTUS? Okay, what did they decide? Let's see if I can move this. I'm not going to read this to you. Here are all the categories. Here's everything they said. This is a WOTUS. So let me give you just some examples, okay? Category 1, all those navigable waters used in commerce. You know, I think about things like the Mississippi River, the Great Lakes, right? Where you got cargo ships and lots of commerce. Category 2, interstate waters and wetlands. I think about lakes that cross state borders. I don't know, Lake Tahoe, maybe. Category 3, intrastate, so meaning lakes and rivers and streams that are only inside of one state that are used for commerce or recreation or fishing. We've got some of those in Arizona, maybe something like a Roosevelt Lake, right? Just to give this some practical import. And then, and I want to mention the 7th category, adjacent wetlands. These are marshy, swampy areas that are close to a WOTUS, that are close to a lake, that are close to a river, right? And most of the WOTUS fights in case law have related to what's an adjacent wetland and can an adjacent wetland even be a WOTUS? And even though Arizona doesn't have a lot of wetlands or an adjacent wetland problem, it's important to know that when the court decides a WOTUS case, even if the genesis of the fight is about an adjacent wetland, what the court decides affects all of WOTUS land, right? So it affects Arizona too. Okay, but what does all this really mean for Arizona? So let's take a look at some photos. Okay, upper left, that's a topographic map of the US. You look at the Western US, whoa, dry, mountainous, arid. You look at the East Coast and you're like, ooh, green, wet, lots of water. Okay, got it. So the US doesn't have the same geography, right? We're a big country, lots of different climate zones, lots of different geography and topography. The bottom photo is really what you would call your traditional navigable water, your traditional WOTUS. I think this one's the Colorado River, and not Colorado, sorry, Mississippi River, and you've got cargo ships going up and down. And this is when people think of a WOTUS or a navigable water or what's protected by the Clean Water Act, they think of something like that. Well, look at the look at the photo kind of in the middle toward the right. Is that a water? Looks like dirt. But what happens in a monsoon? That wash becomes a raging river. And anything you dump into it is flowing down, right? So whether a mine is discharging arsenic and copper drainage into this wash, or whether someone's dumped a car in it with a battery and oil or a refrigerator with Freon or whatever they're dumping in the wash, down it goes, right? If you were to ask Justice Scalia, he would say, well, that is not a water, okay? That's dirt. And this is not anything that we should be protecting under the Clean Water Act. But because water only runs through these washes very infrequently and usually after precipitation events, these waters are known in the WOTUS lexicon as ephemeral waters, okay? You have 3 kinds of waters, really. You have your perennial water, that's your Mississippi River, 365, 24/7 water flowing. The ephemeral is the other end of the spectrum. And then you have intermittent waters that maybe run seasonally, right? You may have a river that runs most of the time, but maybe dries out at the end of the summer. And so maybe there's not a lot of water in it in the summer. So those are basically your 3 kinds of waters. And the big issue in Arizona under the Clean Water Act is whether ephemeral streams like these dry washes are actually protected under the Clean Water Act. Okay. So I mentioned before that the Supreme Court, of course, had to get involved in this. And, in keeping with our theme of a system of mutual frustration, you get the judicial branch saying, hey, we have an opinion too. And we're going to assert some of our power and authority in the WOTUS arena. Congress, you may have passed the Clean Water Act, and executive branch, you may have passed your WOTUS rule, but we're the judicial branch and we have something to say. And there's really a trilogy of 3 cases that's soon to become 4, and we'll talk about that. And these 3 cases are known as Riverside, Bayview, Swank, and Rapanos. Okay, so I'm going to talk a little bit about each one of those so you get the idea. So Riverside Bayview Homes is the first case from 1985. And what happened there is a home builder began placing fill materials on its marshy property that was near Lake St. Clair, Michigan. And Lake St. Clair, Michigan is a WOTUS. But they didn't get a permit. The home builder didn't get a permit from the Army Corps of Engineers before it started, filling this property. The Corps found out what was going on and was none too happy and sought an injunction against the home builder to stop them from filling the property without getting a permit. And the district court, the trial court, found that a permit was indeed required. And the district court, their decision was really based on science and botany. They talked about this property being characterized by vegetation that required saturated soil, and the source of that saturated soil was groundwater, and the wetland where this property sat was right next to a WOTUS, namely Lake St. Clair. And so really the district court was deferring to the Corps' reasoning that this marsh was an adjacent wetland that was just inextricably linked with this nearby lake, and that these adjacent wetlands are in fact, properly deemed to be WOTUS that are protected under the Clean Water Act. And the Federal Court of Appeals reversed, okay? And the federal court basically said, look, you have to interpret Clean Water Act jurisdiction very narrowly because these decisions impact people's property rights. And we want to make sure that the Corps doesn't exceed its power and its authority, and to essentially engage in a taking of property without just compensation, right? You have to make sure your permitting requirements aren't so onerous that you're actually taking someone's property. The Supreme Court said, no, Court of Appeals, you are wrong. We're going to defer to the Corps. We agree with the district court that these adjacent wetlands are WOTUS, and that a permit is required. Now, I don't know that Riverside Bayview would be decided the same way today. So between 1985 and now, and very recently, there's been a shift in the Supreme Court, more conservative court, a court that has been more skeptical about deferring to administrative agencies and their reasoning and their decisions. We've had some environmental law cases that have dealt with things like the major questions doctrine, which involves what kinds of questions can administrative agencies really answer, how much power do they really have. And I don't think now an administrative agency is going to get the kind of deference at the Supreme Court level that the Corps got in Riverside Bayview. Okay. Next slide, Swank. This is the other, a case that's sort of the other end of the spectrum. And in Swank, the Supreme Court found that the Corps did in fact exceed its authority. So in Swank, we have something called the Federal Migratory Bird Rule, and it's a regulation that protects migratory birds, right? And the Corps wanted to use the Federal Migratory Bird Rule to justify requiring the Solid Waste Agency of North Cook County, Swank, to get a permit under 404. And the Corps wanted Swank to get a permit to protect all those little birdies, migratory birds that use the pond, even though the water at issue was kind of like this isolated pond. And the Supreme Court basically said, look, you guys, you went too far. This is a non-navigable, isolated pond. doesn't cross state borders, doesn't have any connection to any traditional navigable water anywhere. And so it's not a WOTUS, and you can't require a permit even when your intentions are good and you're trying to protect little birdies. You can't do that. So I think what everyone thought at the time is, between Riverside Bayview on the one hand and Swank on the other, we all had a kind of a good understanding of the line, right? And what kinds of things could be regulated is a WOTUS, and what kinds of things couldn't when things went too far. So we thought. And now you get the problem. Rapanos. Oy. Okay, here's what happened in Rapanos. The Corps of Engineers brought civil enforcement proceedings against several property owners who were backfilling their properties without a permit. And these properties were on wetlands in Michigan that were near ditches and man-made drains that emptied into a WOTUS farther downstream. So think about this as, you know, the knee bone's connected to the thigh bone's connected to the hip bone, right? So you got these wetlands and you got these ditches, and then you got this WOTUS. And you know, in Rapanos, the district court and the federal appeals court all agreed with the Corps that you know, a permit was required in this situation. And then you get to the Supreme Court. The Supreme Court accepts review of Rapanos, and wouldn't you know it, they couldn't make up their mind. Okay, and we have three factions. We have a plurality decision, and a plurality decision is one where a majority can't make up its mind. We have 9 justices on the Supreme Court, so normally to get an answer to a legal question, you need 5 of them to agree. And here you had an opinion, you had 3 sets of opinions, so you ended up with an opinion that was 4, 4, and 1. This is the kind of stuff that makes lawyers rip their hair out. Okay, this causes pandemonium when this happens. So you have Justice Scalia and 3 conservative justices who basically say, unless a water is relatively permanent, flowing 24/7, it's not a WOTUS. It's not protected under the Clean Water Act. You can't have land as water jurisdiction, you know, no. Then you kind of have Justice Stevens, and 3 of the more liberal justices who say, wait a minute, we already decided this issue in Riverside Bayview. We already have a rule for this. And Justice Scalia, your opinion is just off the rails, okay? Then you have Justice Kennedy. I mean, this is starting to sound like the Talmud, okay, which is just this book of rabbis arguing with each other and explaining why all the other ones are wrong. And so Kennedy is like, you're both wrong. Here's what I think the rule should be. I agree with none of you. And I think that a wetland that has a significant nexus to a navigable water is what should be jurisdiction under the Clean Water Act. Well, what the heck does that mean? So he goes on to explain what he thinks about this. This is a very sciencey approach. Okay, waters or wetlands, you know, have a significant nexus if either by themselves or in combination with other similarly situated waters significantly affect the chemical, physical, and biological integrity of those nearby or connected navigable waters, traditional navigable waters. And, you know, you can't just speculate that there's this relationship. You actually have to prove it with data. So, you know, this kind of science-based approach really looks at what the effects of polluting a wetland would be on these other nearby traditional navigable waters. I'm going to have to open a door real quick. One moment. Why are you whining? There you go. My washing machine was going, and I didn't want everyone to have to hear my washing machine spin, and I shut a door anyway. It's caused pandemonium with my dogs. So a scientific approach about, hey, if we're dumping pollutants or filling wetlands, are they really going to, is it going to have a negative impact on downstream WOTUS, on downstream traditional navigable waters? And if so, these wetlands get protection under the Clean Water Act. Okay, so in my law practice, just so you kind of know sort of what I do, is when it comes to these kinds of scientific questions, I have my client show me the data that they've collected, okay, to show a significant nexus. And I make sure that I understand the science and can effectively put my client on the stand to explain it, and convey these highly scientific concepts to a fact finder or a judge who may not really have an environmental law background. And so as a lawyer, if my client says there's a significant nexus and I say, well, okay, great. And I just say, okay, and accept that, I'm not really doing my job to be a competent advocate. If I don't take the time to review the data and understand the science, then how am I going to be able to assess whether I believe my client's data is going to withstand scrutiny and whether I can explain it persuasively to a judge? Okay, so that, my friends, is our ethics minute, and I'll stop. But this is why sort of my job as a lawyer, sometimes I have to be a hydrologist too. Sometimes I have to be a geologist. Sometimes I have to try to be a chemist, or at least not so much be that, but understand it. Okay, to make sure that I'm doing my job properly as a lawyer. Okay, so which Rapanos opinion wins? You have 3 opinions. Who wins? Well, I won't explain all of this nonsense to you based on the Supreme Court and Marks. You can read it if you want. You have the slides. But suffice it to say that Justice Kennedy wins. And so significant nexus became the test after Rapanos was decided. So womp womp Stevens in the 3 and womp womp Scalia in the 3. Justice Kennedy wins for now. So in December 2008, EPA and the Corps, they issued a guidance document, and they said, look, we've got this new court decision. Here's how we think we should apply it in the field. And here's what we think, all you states, and what we're going to do in terms of incorporating Rapanos in our permitting decisions. And what's important about this for Arizona is that the Rapanos guidance specifically addressed ephemeral waters here in the arid West. And they basically, ephemeral waters under the Rapanos guidance are protected under the Clean Water Act if any of these 4 things are true. Okay, most commonly you have number 2. If these washes collect and transport water and sediment downstream to other waters following precipitation events, then these ephemeral waters do get protection under the Clean Water Act. If they provide habitat for wildlife and aquatic organisms in the downstream traditional navigable waters, okay, they are protected under the Clean Water Act. So I think this probably made some people happy. People that are looking to make sure ephemeral waters in the arid West are protected probably appreciated the Rapanos guidance. Okay. Maui is fascinating and it's WOTUS adjacent, but I don't know that we have time to discuss Maui. If we have time, we'll go back to Hawaii. We'll take a little detour to Hawaii and talk about sewage because that's everybody's favorite topic. Okay. So for 30 years, we all operated under our 1986 Reagan era WOTUS rule, as later modified by Rapanos. And I think even if you didn't like that rule, you knew where you stood. If you were a business, you pretty much knew when you needed to get a permit. If you were an agency like ADEQ, you knew how to write those permits so they were compliant with the Clean Water Act. And then the apple cart gets really upset, okay? In 2015, again, why do they do this right before they leave office? You'll see this happen twice. Obama, he's out the door next year. He issues a new WOTUS rule that was really influenced by kind of environmental or green groups to expand WOTUS. And it had a much broader interpretation of what should be protected under the Clean Water Act. It was a very sciencey approach. And of course, everybody sued, right? Every red state in the country sued, the home builders sued, you know, every sort of industry group you can imagine sued. And the Clean Water Rule ended up being enjoined in Arizona, and it never became effective. Okay, so we never, it just never came to pass in Arizona. And then President Trump, he's about out the door, and he's like, oh no, I'm going to write a rule too. So you have sort of this middle of the road Reagan era rule. Then you have the Obama administration who swings the pendulum this way. And then you have the Trump administration who just swings it completely the other way. And the Trump rule seized upon kind of Scalia's decision in Rapanos, that, you know, it's these relatively permanent bodies of water that are WOTUS, and everything else, forget about it. And significantly for Arizona and other arid Western states, this rule specifically said that ephemeral waters were not WOTUS and had no Clean Water Act protection. So of course, everybody sues, only it's the other side suing. It's the green group suing, right? Everybody on the other side of the environmental coin sues over the NWPR, this Trump rule. And in courts in Arizona and New Mexico remanded this rule with vacature. It's gone, okay? this rule is just booted. And following the first court to vacate the rule, that was the District Court of Arizona. A judge from the District Court of Arizona remanded this rule with vacature. And once that happened, EPA and the Corps halted the implementation of the NWPR nationwide. They just stopped enforcing the rule, and everybody went back to, you guessed it, the 1986 Reagan era rule. So here we are back to that. I think going back to the 1986 rule, actually, you know, a lot of people liked that because they were back with, you know, because you have certainty, right? Everybody at ADAQ knew how to write permits now, again, right? And they weren't changing the way they were doing things with this pendulum. And think about it, if you're a business, most businesses comply with the law, and most businesses come from the perspective of, just tell me what I need to do to run my business and I'll do it, okay? And if a rule is passed, even if it's kind of stringent, if that rule withstands, you know, court scrutiny, businesses are gonna, you know, they're going to change the way they do business. Maybe if they're in the air pollution realm, there's a new rule, they're going to retrofit their buildings or change the way they're doing things to comply with the rule. So even if another president comes along and the administrative agency led by his administration changes a rule to make it more lenient, a business is going to be like, but wait a minute, I already changed everything. I already made all this investment, already changed the way I was doing business to comply with the rule. So making it lenient doesn't make any difference to them, right? Because they've already made the changes they need to make. So, you know, there's something to be said for certainty as opposed to just the pendulum swinging. But let's talk about what happened in Arizona during the time that the NWPR, this Trump rule, was in place. Okay, the irony is that on paper, the NWPR changed everything. On paper, the rule was designed so a lot of businesses didn't need to have permits anymore and could just do whatever they wanted. That was sort of the goal of the rule, but that is not, in fact, what happened in reality. So did the NWPR actually end protection of Arizona's ephemeral waters? Actually, in practicality, it didn't. Did permittees seek in droves to terminate their permit because they were no longer discharging pollutants into a WOTUS? No, just about everybody kept their permit. So why risk? As we talked about, if you're a mining company and you're discharging mine, you know, drainage water into a wash, and it contains, say, copper and arsenic, okay, and you're dumping it into a wash, If that wash is in a WOTUS, technically you don't need a permit because you're not discharging pollutants into a WOTUS. But what happens in August when that big monsoon storm comes, or in July, and all that copper and arsenic that you've dumped into the wash has now flown into the Colorado River, which is a WOTUS? What if someone stands where the wash meets the river and takes a little sample of the water and finds copper and arsenic? They're going to say, that mine, it's from that mine. And if those pollutants make their way from the wash into the big river, you've now discharged pollutants into a WOTUS without a permit. And now you're in big trouble. So most companies, most people that had permits kept their permits because of this risk. They did not want to have the risk of liability under the Clean Water Act. So they were willing to keep their permits and limit the pollutants they were discharging into those washes. But in the meantime, Arizona didn't know that. They didn't know how this was going to turn out. And so Arizona actually passed some legislation to create a state waters protection program to protect some waters that were not WOTUS, that would no longer be WOTUS under the rule. It didn't really help much with ephemeral waters, but it helped with certain other categories of water. And, you know, but then the Trump rule went away. So maybe all of this work that the legislature did and that ADEQ did to pass this law, maybe it was for naught, right? Well, hang on. It really wasn't. Hold that thought and then hold one more thought. After the NWPR was vacated, the Biden administration said, enough of this pendulum. We're going to create the WOTUS rule to end all WOTUS rules. Okay. And we're going to solve this, and we're going to create a rule that's so durable. It's going to survive the pendulum swinging. It's going to survive through administrations. We're going to do it. We can do it. And so in January of this year, the Biden administration did issue that rule. And it is the most vanilla, middle of the road rule you can imagine. It's everything that was in the 1986 rule, plus the stuff from Rapanos that needed to be added to it. It really is a status quo rule. But don't let that stop people from challenging it. There's already been multiple lawsuits challenging the rule by various industry groups and red states. And I just read that some of those lawsuits have been consolidated into one litigation. So they're already suing. But just hold that thought, because that may not matter at all. And I'll tell you why. Michael and Chantel Sackett. I hate these guys, and I'll tell you why I hate them. Again, my personal opinion. So hang on. I got to go back. I got really excited here because I hate these guys. Okay, so the Sacketts have been feuding with EPA in the Corps since 2007 about whether they need a permit to build on their lot in Ohio. And basically, they have this really marshy, sort of swampy lot next to a lake in Idaho. And they're the most unsympathetic plaintiffs that you could find in the world for two reasons. One, when they bought their lot, there was an environmental report that came along with it so they knew when they bought their lot, because this environmental report said, hey, before you can build a house on this lot, you need a permit under the Clean Water Act. So they bought this lot knowing that they would need a permit to build on it. And then they bought the lot anyway and then sued because the government made them get a permit. So these people were not duped, they knew what they were doing. And then Michael Sackett. During this whole time of this feud, Michael Sackett spent a number of years in federal prison during the time of this feud because he got caught in an FBI sting trying to have sex with underage trafficked girls. So again, I hate this guy. This is like the most unsympathetic man in the history of people. But the Sacketts have a public policy group paying their legal fees in this litigation. A group that really just is like, big government is communist. Okay, so that kind of thing. And so their litigation is being funded by another group. And their case has been up to the Supreme Court already once on kind of a more procedural type issue, and it's been all through the courts, and they've never won on the ultimate issue. They've always lost on the issue of whether they need to get a permit. Time and time again, they've been told they need to get a permit. So last year, they filed another appeal to the US Supreme Court with a whole slew of issues that they were asking the court to review. And the Supreme Court refused to look at any of the issues they raised that they wanted the Supreme Court to look at, except for one. They accepted review on one issue, and that was whether significant nexus is the proper WOTUS standard. So if you remember back when Rapanos was decided in 2006, there were only 4 votes in favor of a narrow WOTUS rule. Only 4 votes in favor of a rule that said only these permanent waters used for navigation get protection under the Clean Water Act. I think now that the court has a more conservative makeup, I think they accepted review of this case because they think they have the 5th vote. The 5th vote to overturn Rapanos, to overturn probably Riverside Bayview, and adopt Justice Scalia's version of the Clean Water Act and how that should look, okay? So for all of this, Biden's rule is probably dead on arrival. We're getting oral argument in the Sackett case took place in October, and we're waiting for an opinion in the spring. And if you ask me, what I think is going to happen is the Supreme Court's going to overturn Rapanos, probably overturn Riverside Bayview, and adopt Scalia's version of what a water of the United States looks like, that very narrow kind of vision of it. And Arizona's ephemeral waters are going to be left without any protection at the federal or the state level. And in Arizona, it's going to be up to the mercy of companies who are willing to keep their Clean Water Act permits. Because frankly, even if you're dumping pollutants into a wash, and even if that wash is far enough away from a bigger river that it never reaches the Gila, it never reaches the Colorado, think about what you're dumping into that wash, and thinking about what happens when it rains, and think about all the wildlife, right, that uses that water, drinks that water, people may be in that water. And what if it is filled with arsenic or lead or God knows what, right? There's a reason to want to, there is a reason why Justice Kennedy talked about significant nexus, and why the government felt that ephemeral waters should have protection also. All right, that's my soapbox. But the Sacketts, they want their own test. They think they're smarter than Scalia and Kennedy and everybody else. And they're also, like the Court of Appeals in Riverside Bayview, they're also concerned about their property rights. They want their property rights respected, and they want a WOTUS rule that ignores science completely. They want a WOTUS rule where any layperson can just look at the ground and decide whether they need a permit. And if you can't readily see it, then the government can't make you get a permit. So not only does it reject, all principles of science, it ignores the US Supreme Court's decision in Riverside Bayview. So not personally a fan of the Sackett test. But everybody has an opinion on WOTUS. So when the Supreme Court accepted review of Sackett, they accepted 43 amicus briefs from environmental groups, industry groups, Native American tribes. Hundreds of members of Congress banded together to file amicus briefs. And just about every US state and the District of Columbia filed an amicus brief, which is a friend of the court brief, where they were sharing with the court what they thought should happen in the case, okay? And giving the court their insight. So even if you're not a party to a case, if you have a perspective on a case that you think may be helpful to the court, you can ask permission to file what's known as an amicus brief and share your thoughts with the court so the court can take that into consideration. So again, oral argument was in the fall. We're expecting an opinion in the spring. And my prediction is that significant nexus is gone, and we're going to have a very narrow rule that leaves most of Arizona's waters wholly unprotected under the Clean Water Act. And that's it. That is my presentation. I'm going to stop sharing my screen, and I hope I didn't bore everybody terribly. And I'll answer any questions. We've got a few minutes for questions, and sorry I had to skip a lot. Someday we can talk about Maui because that's a great case. But anybody have questions, comments, tomatoes they want to throw? Oh my goodness. Okay, Henrietta and then Susan.
Yes, my question is, are Indian reservation lands included in WOTUS?
So a WOTUS is basically just deals with the water and whether the water is protected. So yes, so if a water, say the Colorado River is a WOTUS and it runs through lands that are state trust land, it runs through lands that are on Indian country, that water is still protected under WOTUS. Susan.
Any prediction as to whether or not the Arizona legislature might step in and protect our ephemeral streams?
Let me this is politics. No. So nothing is going to change until we change the composition of people we elect to the legislature. As long as the legislature has a Republican majority that's very business oriented and friendly toward business, I do not see the Arizona legislature promulgating any significant environmental protection legislation, because the argument on the other side is this costs jobs, this costs businesses money, businesses aren't going to come to Arizona if Arizona is highly regulated. Don't California my Arizona. You've probably heard that. So I just think that with the current composition of the legislature, I'm not hopeful. And you have to realize that when Arizona went through the process of trying to pass the State Waters Protection Program legislation, you can imagine all the political machinations that went on at the legislature trying to get anything passed at all. And again, that legislation does not protect ephemeral streams. So sorry, that's my pessimistic opinion right now, but it's changing. Things are changing slowly, either for the better or the worse, depending upon what side of the aisle you're on. Any other questions? And sorry, you're just getting my unadulterated, just pure Shelley personal opinion, okay, for whatever it's worth.
Shelley, this is
Yes.
Mary Schroeder. Congress could amend the Clean Water Act, couldn't it?
Absolutely. And the chances of that are also pretty low. I mean, if you think about, I'm thinking about laws about immigration, okay, for example. We have had times in our recent governmental history where you had a president and both houses of Congress, all of the same party, and nothing got accomplished, right? And so in terms of a lot of this, and there have been times when you've had a president in both houses of Congress of the same party, and they haven't made any changes to the Clean Water Act either. So I think that's a difficult thing to do. Now, the question is, if in the SIPhx case, the Supreme Court adopts a very narrow definition of WOTUS that leaves a lot of waters unprotected, the question is that decision going to be enough to get Congress to act and actually define WOTUS in the Clean Water Act? I mean, just as a citizen of the US who likes to have unpolluted water, I would hope that would happen. But I really haven't seen, I'm just not hopeful of it, right? Once it gets in that political process, Sorry, I'm just cynical about it. Margie.
So for all of you Desert Botanical Garden members, the garden over several years has in some cases been part of the testing that, either the, USDA or Wildlife Services or Game and Fish to actually do some of the testing on the vegetation. We've done work on, the impact of wildfires and what that's had to the soil and things like that. So there's a lot of research that's actually going on to kind of do what you're talking about, Shelley, with all the waters and the wetlands, and that they exist in Arizona. So just wanted to kind of share that out.
Yeah, and ADEQ, even though the significant nexus test may be going by the wayside, ADEQ scientists are really busy doing all of the work necessary to collect the data to determine which waters have a significant nexus to those bigger traditional navigable waters in Arizona. And, I think if you were to ask somebody ADEQ, they would say that, that science is important to have, even if the rule changes. It is important to have that data and that information about waters in Arizona.
Yeah, and those grants go over several years. So
Yeah. There are a lot of scientists hard at work. And I'm just lucky that I get to kind of talk to them every day and see the data and see the things they're working on. It's kind of like that Donna Summer song, they work hard for the money, so you better treat them right. They're not in it for the money. They really work hard and try to do the right thing with pretty limited resources. Henrietta.
When I first moved here in 1977, I remember reading that there was a lot of contamination of the water from Motorola. And
Oh,
it
okay.
was along Indian Bend, McDowell?
Yeah,
and
yeah.
it required a lot of cleanup. Was that totally taken care of?
Sure. So we're going to get into another environmental law arena, and it's called CERCLA and WRF. Okay. CERCLA, you probably know, it's a federal law, and you probably know it is the Superfund law. If you think about like Love Canal in New York, right? Where these historic sites are contaminated. A lot of times it's groundwater contamination, soil contamination. The federal government can put these sites, can score them and put them on a national priority list and make them Superfund sites, and there's a fund of money to clean them up. Arizona has its own sort of state CERCLA statutory scheme called WRF, Water Quality Assurance something fund. Water Quality Assurance Revolving Fund. Anyway, WRF. We love our acronyms, WRF. And WRF, a lot of the sites that you're talking about are state Superfund sites under WRF. And what happens there is there are kind of investigations, remedial investigations that are done. You actually look to find who the potential responsible parties are for the contamination. And if there are companies that are still in existence, you can get money from them, make them pay a proportional share to clean up the site. Responsible parties who actually take action to clean up the site can go into court and get cost recovery sometimes for the work that they've done. So there are a number of WRF sites in Arizona, and they will be WRF sites for decades. So between the time it takes to investigate the contamination, find all the responsible parties, get all the money to clean it up, actually clean it up, it takes many, many decades. But we can talk about WRF another time if you really want to be bored. But yeah, those sites will go on forever. I will die and they will still be WRF sites.
Yeah,
Lee.
Shelley, during your presentation, all I could think about was Flint, Michigan. The horrors of that situation was just awful. And then the fact that, it just kind of nothing that I know of, what came of that. It's horrible.
So in Flint, they changed the source of the water, and because of that, you had a lot of leaching of lead from old pipes into the water system, and lead is so particularly damaging, especially to children in terms of just brain damage and just destroying. I mean, it just destroys people. And it was a decision that I think was a financial decision that was made by administrators who had no like scientific knowledge whatsoever. So in my presentation, when I talk about how I let the scientists be scientists and I listen to them and I look at their data and I analyze it and I make, you know, my legal assessment of its validity, I can't impress enough the importance, the how important it is for lawyers, for administrators in government to listen to scientists and partner with them and learn from them in order to make good decisions. I can't make good legal decisions in this arena without taking a lot of time to understand science. I have to read crap in the Federal Register with like equations this long, and I just lose my mind. I have to call somebody because I'm like, I don't do this. You're going to have to explain this to me. And they're so nice, you know, they teach me hydrology for dummies, essentially, you know, and work with me to make sure that I understand what I need to understand so I can go into court, make a coherent presentation and, you know, help my client win the case. And I learn a lot in the process. For somebody who studied Russian intellectual history in college, you know, and took a geology class and that was it. It's one of the best parts of my job is to be able to learn about all of this science stuff, you know, without the equations, put those aside. Well, thanks everybody for listening on a really like esoteric topic. So
Thank you.
Thanks,
All right.
Shelley. It was really interesting.
Shelley.
Yes,
yep.
thank
Well,
you.
have a great day, everybody.
You
Enjoy your
too.
afternoon.
Bye.
Bye.